A man identified in one fragmentary account as Elias Colby, described as a night deputy at a federal territorial prison in Nebraska, was not a man who kept records. Night deputies in 1890 did not keep journals. They kept watch. They walked the corridor. They listened to whatever the dark offered, and they said nothing about it afterward, mostly because nobody asked. According to the account, Colby did not speak about what he witnessed until 1931, when he was 74 years old, and a reporter from a small Lincoln paper came to his house looking for colour on the old territorial days. The interview, if it ran at all, ran 3 paragraphs in a local section that nobody indexed or preserved. The clipping survived, the account claims, only because a granddaughter had folded it inside a Bible that eventually wound up in a Lancaster County estate sale, where it passed into private hands and from there into the kind of obscurity that leaves no trail. In those 3 paragraphs, the account records one thing that does not appear anywhere else. The man they called the Giant did not pray on his last night, did not sleep, did not pace the cell or press his face against the bars the way men sometimes did when the hours ran short. He sat, and he sang, low and continuous, in a language the deputy could not identify. For 4 hours, from somewhere around 10 in the evening until an hour before dawn, the singing came through the cell door. Quiet enough that the guard had to hold still in the corridor to hear it clearly, persistent enough that he never stopped hearing it. He said he did not know what the words meant. He was not sure they were words at all, in any sense he could account for, and then he said, in the flattened, careful voice of an old man describing something he had never managed to explain, that it did not sound like a man who had given up. The official court transcript of the 1890 trial, according to surviving accounts, describes the condemned as violent, incoherent, and without remorse. One of those accounts shaped the record. One of them may be closer to the truth. Historical accounts describe a man known to settlers in the Niobrara River Valley as the Giant. Reportedly a Lakota man, well over 6 feet. His exact name disputed or simply unrecorded across every source that survives. Arrested and tried for the murder of a homesteader named Anson Weller. The trial, as these accounts tell it, lasted 2 days. The jury deliberated 40 minutes. He was hanged at the territorial facility that spring, and the regional press covered the outcome in the manner of the era. Law arriving where lawlessness had ruled. The valley was open, the frontier moved on. There was no reason, in the institutional memory of territorial Nebraska, to revisit the case. His name in the court record is listed only as John Doe, Indian. That is the story as the available record tells it. It is worth holding clearly, because what follows is not about adding texture to it. It is about watching it stop making sense. 16 days after the hanging, according to accounts that have not been independently confirmed in accessible archives, a land claim was filed on 340 acres in the Niobrara drainage. The filing came through clean. No contest recorded. No prior claimant listed. No attached correspondence noting dispute or complication of any kind. That same parcel had reportedly been the subject of active federal correspondence regarding its treaty status for at least 3 years, contested in letters between the Bureau of Indian Affairs and the Territorial Land Office as recently as the previous October. After the hanging, the correspondence is said to have stopped. The claim passed without challenge, and 3 weeks after an execution, land that had been legally ambiguous for years was suddenly settled, stamped, and available. This is not where the case becomes interesting. This is where it reveals what it may actually have been. The homesteader allegedly murdered, Anson Weller, reportedly held a land claim adjacent to that same tract, and that claim, according to these accounts, had not been filed after the conviction, not after the trial, not even after the arrest had been formally processed and recorded. It had been filed the same week the arrest was made, before a verdict existed, before a jury had been assembled, before the court had been formally convened. The land claim arrived ahead of the justice, and the justice arrived exactly on schedule. That is not procedural coincidence. That is a sequence with a design behind it. The man they called the Giant had a name the court chose not to use. Lakota oral tradition, as recorded in fragmentary missionary and community accounts from the Niobrara region, preserves a name for him, Tjūašúŋke Sápa, Black Horse. He was, by these accounts, 34 years old at the time of his execution. Not a war chief, not a raider, not a man with a documented history of violence outside of what the trial alleged. He was what his community recognized as a boundary man, someone charged with the specific standing responsibility of walking the physical edge of treaty territory, identifying encroachments, and asserting the community's legal position on the ground where it mattered most. Whether that role was formally recognized in the treaty text or rooted in Lakota customary governance, it placed him at the precise intersection of communal obligation and contested federal law. His role made him a problem, not because he was violent, because he was precise, and precision, applied to a contested boundary line in the Niobrara Valley in 1890, was something certain interest could not afford. One photograph of him, some accounts claim, survives. It was taken at the prison the day before the hanging, apparently at the warden's request. In the image as described, he is standing. He is not in restraints. He is looking directly at the camera with no performance in his expression, no arranged grief, no displayed defiance, no plea. He is simply present in the frame. The photograph, it is said, ran once in a Denver paper the day after the execution, under a 2-line caption, "The last of his kind." A chapter of frontier violence now closed. He was 34 years old. Consider what Anson Weller was reportedly doing in the months before he died. Weller had been fencing the boundary line, not near it, but on it, driving posts that moved the effective edge of his claim into territory the Lakota considered their own under existing treaty arrangements. Illegal fencing and boundary encroachment on treaty and federal land were documented practices across Kansas, Nebraska, and Dakota territory in this period, applied systematically since at least the 1870s. A fence already set into the ground was harder to dispute than a line drawn on a government survey map. By the time a legal challenge could be organized, submitted, and heard, the fence would be weathered, the land behind it turned and planted, and cultivation carried its own persuasive weight in territorial courts, regardless of what treaty language specified. Black Horse confronted Weller. He pulled down a section of fence. There was a physical encounter. This is consistent with the settler testimony introduced at trial, though none of that testimony addressed anything that happened to Weller in the 2 weeks that followed. Weller was found dead 14 days after the confrontation. County coroner's notes, according to accounts that cannot be independently traced in accessible archives, described the cause of death as a fall or blow, possibly self-inflicted by accident while working. That word, possibly, was reportedly present in the original document. It was not in the trial record because the notes were allegedly never entered as evidence. The coroner was not called to testify. The document was not presented to the jury, not challenged, not rebutted, simply absent. A researcher working the case in the late 1960s is said to have located this document in a county archive. A graduate student whose work on the case, for reasons that themselves bear examination, was never formally published. What the trial actually established, the only thing it established through direct testimony, was that a Lakota man had confronted a homesteader about a fence, that the fence had been pulled down, that Weller had died 2 weeks later. The causal link between those facts was not proven, it was asserted. In a territorial court in 1890, with a 40-minute deliberation and a defense attorney who called no witnesses and submitted a 1-page brief, assertion was enough. The hanging was not punishment for murder, it was punishment for resistance. The land filing that followed was not a consequence of justice, it was the completion of a transaction that had been initiated before the verdict was read. Step back from the case because the pattern does not stay local. Across Nebraska and Dakota territories in the decade between 1880 and 1890, researchers have identified a recurring alignment in the territorial record: capital cases involving Native men convicted of crimes near contested treaty land, followed within weeks or months by land filings, boundary adjustments, or treaty renegotiations that resolved the underlying dispute in favor of settlement interests. The specific tallies are difficult to aggregate cleanly from dispersed and inconsistently preserved territorial records, but the directional pattern is visible enough that it cannot be read as coincidence. A result repeated across jurisdictions and years is not an accident accumulating. It is a system operating without a written manual. Federal land correspondence of this era, including communications involving the Bureau of Indian Affairs, returned with notable regularity to the language of property law. The operative concept was quieting title. This is a legal term. It means removing competing claims so that ownership can be established cleanly and transferred without encumbrance. A quieted title sells, a contested title does not. The language of arrest, trial, conviction and execution across this decade was the machinery through which title was quieted. The morality was the packaging. The land was always the point. The official story does not merely fall short of this, it inverts. What was described as law arriving on the frontier was, in practice, a mechanism for moving treaty-disputed land into the territorial commercial market. The trial was the procedure, the hanging was the clearance, and the land filing that followed was the receipt. Colby, or whoever the corridor witness was, said the singing stopped about an hour before dawn. A long silence followed. Then, through the cell door in clear English, the man called the giant spoke one sentence. The fragmentary account includes it. What claims to be the legible portion reads, "They already took. The rest is gone. Already. Not they will take. Not they are taking. Already. Past tense." Something had been removed before the rope, before the verdict, before the trial convened. The land filing was 16 days away. But the sentence, what survives of it, if it survives at all, suggests he understood that the transaction was further along than that. That whatever had been taken was gone long before he entered the courtroom. What was it? The treaty standing that legitimized his work. The coroner's language that might have told a different story to a different kind of jury. His name, 3 syllables in Lakota that appear nowhere in the court record and surface only in oral tradition and fragmentary regional accounts. Or was it something the trial had been structured from the outset to remove? Something whose absence left no legal ground for a man to stand on, no argument that any court in the territory was arranged to hear? The answer requires looking at who built the machinery, not the frontier as an abstraction. Specific men, specific offices, specific interest with specific ledgers, and specific parcels of ground already circled on their maps. Those interests existed, the numbers existed, and the numbers are where this stops being about one case and starts being about a business model. The attorney appointed to represent Black Horse at trial, his name given in some accounts as James Prewitt, left a record in the case that is easy to reconstruct because it is almost entirely blank. No pre-trial motions filed, no witnesses called. A one-page brief that argued in general terms the inadequacy of the prosecution's evidence without specifying which evidence or why. The trial lasted 2 days because the prosecution took 2 days. The defense, in practical terms, took an afternoon. What makes that record legible as something more than negligence is a question of who paid the appointed attorney. In the territorial West, it was documented that court-appointed attorneys sometimes held financial ties to parties with direct interest in land at stake in a capital case. Whether that applies precisely here cannot be confirmed in any archive currently accessible. What can be confirmed is the structural incentive, a development interest holding a pending purchase agreement on contested land, contingent on resolution of a treaty dispute, had every reason to want a swift and uncontested verdict. The verdict arrived swiftly, uncontested. The attorney defending the condemned man may have been paid by the interest that stood to profit from the land his client died to clear. That arrangement, documented in other cases of the period, is entirely consistent with the outcome here. The specific transaction, if it existed, has not been traced in surviving records. This pattern was not always unknown at the time. The Indian Rights Association, a Philadelphia-based advocacy organization that did correspond with the Bureau of Indian Affairs on matters of due process and native legal representation throughout this period, submitted letters flagging attorney conflicts of interest in territorial capital cases. Some were answered, some were filed and ignored. Whether this particular case generated such correspondence cannot be confirmed. What the BIA's response pattern to such letters often looked like is visible elsewhere in the correspondence archive. Receipt, date stamp, filing, silence. Consider the numbers now, because the accounting is where the machinery becomes fully visible. Federal uncontested land in territorial Nebraska sold at rates that development interests could acquire cheaply and resell at multiples within years, a documented feature of the territorial land market. Land that moved from treaty contested to legally settled could change hands at margins predictable enough to be modelled before acquisition. A firm holding a contingent purchase agreement on disputed land did not simply wait to see what the courts decided. It incorporated the expected outcome into the plan. The hanging was not a factor such firms responded to after the fact. It was a factor consistent with the model already in place. This is where the individual case stops being a case and starts being a circuit. Land development firms in the 1880s routinely maintained relationships with territorial attorneys. Territorial attorneys were appointed, not elected, by judges and administrators who themselves held or had recently held interests in territorial land development. The appointments moved through networks with their own gravitational logic. Men who knew men, offices that served the same capital, dockets shaped by the same pressures that shaped the land market. No memorandum described the arrangement. None was needed. Shared context produces shared outcomes without explicit instruction. The distinction between a policy and a pattern is enforced by whoever controls the language, and in this case the same people who controlled the courts also controlled the language. Nobody called it a system because everyone inside it called it progress, and progress was a word that described results without describing mechanisms. 3 years before the hanging, Congress passed the Dawes Act of 1887. The public framing was benevolent. Give native people individual land plots, end communal tribal arrangements, integrate them into the structure of American economic life. Eastern newspapers ran favorable commentary. The legislation was presented as a civilizing reform, a path toward participation. What it actually produced was surplus. Once individual allotments were assigned within a tribal territory, the remaining land exceeding what the allotment formula allowed, was designated surplus and reverted to the federal government, which sold it. Development firms bought it. Over the following decades, the Dawes Act transferred approximately 90 million acres from tribal holdings into the commercial market through entirely legal channels. But legal channels moved at the pace of correspondence and committee. Violence, where it occurred, moved faster. It quieted title in weeks instead of years. It resolved ambiguities that bureaucracy might take a decade to settle. The Dawes Act needed the territorial courts. The territorial courts needed cases, and cases needed at minimum a boundary dispute and a dead homesteader and a jury that deliberated 40 minutes. The hanging was one instrument in a set of instruments, not the most common, but for a contested parcel in the Niobrara drainage in 1890, sufficient. Now look at the photograph's caption again. The last of his kind ran in a Denver paper the day after the execution, or so the account holds. Similar language appeared in regional papers across Nebraska and Dakota Territory throughout this period, whenever a native man died in conflict with the settlement process. Language of endings, of last chapters, of problems finally concluded. Regional newspapers in this era drew substantial revenue from land development advertising. A paper describing the territorial landscape as contested and legally unclear made that advertising harder to sell. A paper describing each conflict as a final resolution of a disappearing problem made the land look like what development capital required, ordered, finished, and available. The caption was not editorial sentiment, it was market positioning. It told Eastern investors the risk was absorbed, the title was clean, and the ground was ready. The question of Black Horse's name belongs to the same logic. John Doe, Indian. Every document the territorial legal system generated about him carries this designation. His Lakota name does not appear in any court filing, prison intake record, execution ledger, or land document connected to the case. Names in legal records are not administrative convenience. They are jurisdictional claims. A named person exists within the law in a traceable way, with standing, with ancestry, with a documented role, a treaty right with a paper trail behind it. A person entered into the record as John Doe. Indian has a file number. The erasure of his name from the legal record was not sloppiness. It produced a cleaner document. A document showing no named prior claimant with standing was easier to move through the filing system, easier to attach to a land transfer, easier to sell as unencumbered. A name would have required engagement. Engagement would have required acknowledgement. Acknowledgement would have complicated the transfer. The designation was not indifference. It was precision. The treaty is the final layer, and it changes the meaning of everything above it. The 1868 Fort Laramie Treaty, which grounded Black Horse's boundary walking role in treaty law, was still nominally in effect in 1890. but it had been functionally superseded in 1889 by the legislative dissolution of the Great Sioux Reservation 1 year before the hanging. That dissolution was itself contested. The federal commission sent to obtain Lakota consent had worked around traditional governance structures, obtaining signatures from men who lacked the authority under Lakota law to commit the community. The process was challenged at the time and overridden. Black Horse was hanged under one legal regime for enforcing rights that a prior legal regime had recognized, and that prior regime had been retired through a process his community had actively resisted and could not stop. The trial did not have to address any of this. It did not use his name, and a man without a name in the record carries no history the court is required to consider. Research into this case has surfaced in forms that have not found their way into the published record. A graduate student working in the late 1960s is said to have assembled the key pieces, the coroner's notes, the attorney fee arrangement, the advocacy correspondence, the land filing timeline, the treaty dissolution sequence, and submitted them in dissertation form to a university committee. The committee, the account holds, cited insufficient primary sourcing. Every document cited was a primary source. Whether that work survives in any findable archive, catalogued or otherwise, remains unclear. The gap it leaves behind in its way is one more unanswered letter. Go back to the corridor. Go back to the guard standing still in the dark, holding his breath to hear through the door. 4 hours of singing in a language he could not name. He said, and this language is attributed to him in the 1931 account, that it did not sound like grief. He said it sounded like someone marking something, like someone making a record. That observation carries different weight now. A man who understood that the legal record would not hold him made a different kind of record. With the only instrument they had not yet taken, not his name, already absent from every document, not his treaty standing, retired 1 year before the rope, not his role as boundary man, converted into the charge that killed him. But the voice through the door in the hours before dawn was something no land claim could supersede, and no caption could reduce to a market signal. The acres in the Niobrara drainage, if the account is accurate, are farmland now. The boundary line that the homesteader began fencing, the one Black Horse pulled down, likely, still exists as a surveyed property edge somewhere in that valley. Legal. Clean. There is no marker on it. No name attached to the ground or the corner post or the section line in the county register. The land was quieted. It has stayed that way. The photograph, if it survives, still holds its image. A man standing, unrestrained, looking directly into the lens, 34 years old. The caption called him the last of his kind because that framing closed the account. An ending requires no further explanation. An example does, and an example would require names, dates, a fee arrangement that someone preferred not to document openly, a land filing timed to an execution, a letter with no reply, a box in an archive that no index mentions. Someone needed the story to be finished. The caption was not mourning, it was closure. And closure, in the Niobrara Valley in 1890, was worth whatever the uncontested federal rate was per acre, multiplied across hundreds of acres, compounded forward across every parcel the same machinery cleared in the same decade across the same contested ground. The singing through the door was the only part of it that was never for sale.